the Supreme Court of Canada has deemed abortion a criminal law matter that is within federal jurisdiction. Consequently, provincial legislatures have very little power to regulate abortion, even if done indirectly. Thus, the discussion on the law on abortion in Canada turns almost entirely around the state of the criminal law. Section 287 of the Criminal Code is the abortion provision drafted by Pierre Trudeau and passed in 1969. Prior to 1969, taking steps to cause an abortion was an offense liable to life imprisonment. However, the Trudeau scheme made an exception for abortions performed in a hospital with the approval of that hospital's 3-doctor therapeutic abortion committee. The committee would have to certify that the pregnancy would be likely to endanger the life or health of the pregnant woman. The term health was not defined, and therapeutic abortion committees were free to develop their own theories as to when a likely danger to health, which might include psychological health, would justify a therapeutic abortion. In 1988, the Supreme Court of Canada decision in Her Majesty, the Queen in Right of Canada v. Dr. Henry Moore-Gendler, Dr. Leslie Franks-Moling and Dr. Robert Scott, indexed by the court as R.V. Moore-Gendler, declared this entire section to be of no force or effect, because it was held to violate Section 7 of the Canadian Charter of Rights and Freedoms. Section 7 states that everyone has the right to life, liberty, and the security of the person and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. The majority of the court held that the structure of the system regulating access to therapeutic abortions is manifestly unfair. It contains so many potential barriers to its own operation that the left square bracket exception right square bracket it creates will in many circumstances be practically unavailable to women who would prima facie qualify. As such, the provision was held to violate the principles of fundamental justice and was struck down, leaving Canada with a legislative vacuum to this day. The court did not consider the question of whether the unborn were included in the everyone who have the right to life. The court was to hear Manitoba Mlajo Borowski later that week with that very question as the central issue, but the case was rendered moot by the decision in Moore-Gendler which struck down the provisions that were to be challenged. The court has never considered the issue. Early attempts to fill the legislative vacuum failed politically, and no government has since dared to touch the issue. However, in a subsequent court decision, R.V. Sullivan 1991 1 SCR 489, the court confirmed that a fetus is not a person until it is born and fully outside the woman's body. The majority of the court in Moore-Gendler did not go so far as to find that Section 7 contains a substantive right to abortion. The seeds of this argument are arguably found in the decision, but as such, it was only explicitly argued by Wilson J. and not for the majority of the court. Strictly speaking, the court found it unnecessary to consider whether the substance of Section 7 implies a right to abortion, but instead made its decision on narrow and merely procedural grounds. The practical result is that it is still open to Parliament to impose some restrictions on abortion within the present jurisprudence and without the use of the notwithstanding clause. However, such restrictions would surely be met with vehement opposition, and the court could very well explicitly read in a right to abortion into the Charter in a future decision. On the other hand, a future court could echo the dissent of LaForest and McIntyre J.J. or go further, the proposition that women enjoy a constitutional right to have an abortion is devoid of support in the language of S7 of the Charter or any other section. The end result, then, is that there is no criminal regulation of abortion in Canada. The 1989 Supreme Court of Canada case of Chantal Daigle, Tremblay v. Daigle 1989-2 SCR 530 is one of the most widely publicized cases concerning abortion in Canada, after the law prohibiting abortions was overturned by the Supreme Court of Canada. Daigle's ex-boyfriend obtained a restraining order against her having an abortion. While the restraining order was issued in Quebec, it was legally restricting Canada-wide. The Supreme Court of Canada ruled that only the woman could make the choice. The father had no legal say in a woman's choice to terminate a pregnancy or carry it to completion. Daigle had already had a late second-term abortion before the ruling of the court. While the case was fast-tracked, the progress was so slow that Ms. Daigle would have been in the third trimester had she waited for the ruling to be handed down. The fact that Daigle had an abortion in the United States, while the case was before the Supreme Court of Canada, was not made public until after the ruling, although it was not unexpected. This is in contrast to the Roe v. Wade case in the United States, where Roe had carried the pregnancy to term. That case, however, was different from the Daigle case in that it was about whether abortion was legal. In the Daigle case, the question was whether a male partner has an equal say in whether a woman can obtain an abortion. Abortions in Canada are provided on request and funded by Medicare to Canadian citizens and permanent residents, as with most medical procedures, in hospitals across the country. Abortion funding for hospitals comes from the various provincial governments. Their overall health expenses are however paid for in part by the federal government. 1/3 of hospitals perform abortions, and these perform 2/3 of abortions in the country. The remaining abortions are performed by public and private for-profit clinics. Medical abortion is available in Canada on a limited basis using methotrexate and misoprostol, mifepristone, more widely known as Rue 486, is not legally approved, and importation of that drug in Canada is currently illegal. Clinical trials were done in 2000 in various Canadian cities comparing methotrexate to mifepristone, after approbation by the federal government. While both drugs had overall similar results, mifepristone was found to act faster. As of May 2005, it is unclear whether or when Rue 486 will be approved for use in Canada.